How are you going to prep for that real estate exam? You're going to prep with Wild Lillie Handy of YouTube Agent Prep with vocabulary. But today we're doing questions, national and Texas state questions. So let me share the book that we're doing. Anyone that's watching a replay, this class is designed to allow students to participate, so you can fast forward through the questions to get through them a little bit faster, since I give time to answer questions. So we're continuing on with last week, what's today, Wednesday, with Monday's session. And for anyone that's watching on Facebook, make sure you go to StreamYard.com/Facebook, and let's give StreamYard permission to post your name on here. Okay? Because Facebook is very protective of our information. All right, this is the book we're using. It is in the description below that you can order from this company that I have permission to use it, so not violating the copyright laws. So Texas Real Estate License Exam Prep by Stephen Metling and 3 other authors. His son, Ryan Metling, Dan Hamilton, David Cusick. And this is on Amazon, and they publish these books, prep books, for 25 different states. Okay, let's get with it. Oh, hey, and I just want to share something. I had a friend that makes t-shirts, and it is Tenant training system. So he's my trainer. And guess what? Look at that. He put Wild Lillie Handy on top for me. Awesome. So anyway, he is at the LA Fitness. Awesome trainer that I've got. So thank you, Ron, for creating this t-shirt for me. Look at that. So that's the flag, but look at that. That is weightlifting bars and the stars. Just thought I'd share, okay, that I'm working out and training to get back into shape, which is something that we all have to do. And when we have a career or we have a business, is to make sure we take care of ourselves. Okay, so we're headed with question number 226. Hi, Jaylene. So we're starting out with national questions today, and then moving on to Texas state. All right, so number 26, the type of deed that offers the grantee the fullest protection against claims to the title is the what? A, general warranty deed, B, special warranty deed, C, quitclaim deed, or C, bargain and defend deed. Okay, somebody on Facebook says hello, but I'm not sure who that is. So whoever that is, go ahead and go to StreamYard.com/Facebook. So I posted that right here. Okay, so on the bottom, you see StreamYard.com/Facebook. It's something really quick. Go to that website and give StreamYard permission to post your name here, like Jaylene or Jacqueline. You'll be able to see your name instead of just Facebook user. All right. So okay, so let's see. I've got A. And yes, that is correct. The answer is A. A general warranty deed offers the grantee the fullest protection against claims to the title. So it's the best type of deed to have. There is also the special warranty deed, and that is just for the current ownership only. General warranty deed covers the whole history of the property. So the answer there is 226A. Very good. Starting out on a good track. Number 27. Let me work on making it larger. Ooh, not quite that large. Okay, number 27. There we go. What is one purpose? What is one of the purposes of a lawsuit to quiet title? A, to force the grantor to defend the title against a third party claim. B, co-ownership estate when one co-owner is unwilling. C, to keep the owner's name out of the title records. Or D, to have an encumbrance removed if the lien holder cannot prove its validity. So type your answer in the chat. What is one of the main purposes of a lawsuit to quiet title? Very good, Jaylene. Yes, D. To have an encumbrance removed if the lien holder cannot prove its validity. And who's the lien holder? The lender, right? Hold on here. My computer is a little bit too high. There we go. So good. Very good. 227D. Shoot. Bear with me, you all. I'm here on my Facebook page and okay, 2.27D. All right, number 28. And I invite all of you to comment, participate, answer the question, even if you're not sure. Go ahead and type it in, and I'll do my best to help you understand it. It's nice and large, but it doesn't include everything. Okay, it's going to have to be smaller. Okay, there we go. Number 28. Okay, so let's say here, Kaylee Hashi says, hi, I love you, Lillie. You're my hero. I just moved to Texas 1 month ago and recently signed up to study for my license just a week ago. So excited. Thank you for all you do. It's helpful. Oh, thank you so much. That's an awesome comment. I greatly appreciate it. So hopefully we can work together. And when you're ready to pass all your classes and then take your exams, let's talk about it. And anytime, comment, text me on Messenger or on the phone number down in the comments. Okay. And there's some books that I recommend down in the comments that you all can buy from Amazon. They're great prep books. Okay. All right. Number 28. Which of the following best describes the documentary stamp tax? A transfer tax based on the price of the property being conveyed. B, a tax a title company must pay in order to examine title records in the recorder's office. C, a tax collected by attorneys and paid to the state when transfer documents are prepared. Or D, a tax on stamps used to certify the authenticity of a conveyance. So what is that? So which of the following best describes the documentary stamp tax? We don't hear about this one very often. So go ahead and, take a risk and type your answer and see whether you answer it right or not. Yes, the answer is A. You did good, Jaylene. A transfer tax based on the price of the property being conveyed. So when the property is being transferred from one individual to another, so that transfer tax based on the price of the property. So sometimes if there are international owners, they have to pay a transfer tax to pay the U.S. taxes. And so that'll be based on the price of the property being conveyed. All right, number 29. Okay, the court proceeding that generally settles a descendant's estate is called what? Okay, the court proceeding that generally settles a descendant's estate is called what? A, testate, B, probate, C, escheat, or D, distribution. Okay, a court proceeding. So far, so good, Jaylene. Yes, it is 2:29. Hey, Tanya, thanks for joining us. Welcome to tonight's class. We're doing national, which applies to all 50 states. So the answer is probate. Okay, so in probate, when they have heirs and maybe there was not a will, then it goes to probate. Escheat is when they don't have any heirs, right? And testate is when they have a will. So if you didn't know all those, it's time to go back to the vocabulary. Okay, so 29 was B, probate. All right, number 30. If an owner of real property dies intestate within, without, okay, and has no legal heirs, what will happen to the property? A, it will escheat to the state or county. B, it will transfer to the descendant's executor. C, it will be divided equally among adjoining property owners. Or D, it will become a public easement. So we just talked about this in the prior question, right? I mentioned what each of the vocabulary meant. So hopefully you'll be able to answer this. So type your answer in the chatty chat. Yes, very good, Jaylene and Jacqueline. Awesome. Yes, the answer is A. It will escheat to the state or county, right? Because it says real property, owner of real property dies intestate without a will. I said within, without, because in means without a will, okay, and has no legal heirs. So it is escheat. Nobody's cheated out of it, especially if somebody said, well, they told me that I could have it after they passed away. Well, unfortunately, they didn't put it in a will. Okay, this is going to have to be small. Okay, there we go. All right, number 31. A municipality wants to build a sewer treatment facility, which will require the acquisition of several parcels of privately owned land. What legal power enables a municipality to buy the necessary properties even against the owner's wishes? Remember, this is one of the police powers. So from A through D, A, estoppel, B, escheat, C, alienation, D, eminent domain. Which one is a police power? And if you're not familiar with the answer here, then it's time to go to your vocabulary. However, everybody's got it. Yes, it is D, eminent domain. It's the right to take property for public use, even against the owner's wishes. However, they have to pay current value, property value, okay? They have to compensate property value. So eminent domain is the right to take ownership. Condemnation is the act of taking ownership. So that is the action of actually taking it. Very good. All right, number 32. An adverse possessor must be able to successfully demonstrate that he or she has been what? A, openly possessing. So an adverse possessor, adverse possession. So what is adverse possession? They have to demonstrate that they have been what? A, openly possessing and claiming the property without the owner's consent. B, occupying the property without an occupant permit. C, using the property intermittently and without permission over a period of years. Or D, building a permanent structure on the property. So when they're taking property an adverse possession, how do they have to successfully demonstrate that? And typically it requires them using it for several years. And then to go to court and get control of the property. Type your answer in the chatty chat. All right, let's see. D, C, C. Oui, monsieur. So 32 is A, okay? C sounds like it is. But A says openly possessing and claiming the property without the owner's consent. So to claim legal title, the adverse possessor must be able to show a claim of right or color of title as reason for the possession. Have notorious possession without interruption, has to be continuous, which is possession without concealment. So in other words, they're not concealing it. It's open, able to be seen by anybody, and the owner could have seen it. Maintains a consistent claim of hostile possession, which is a claim to ownership and possession regardless of the owner's claims or consent. Occupy the property continuously. Okay, that is a key word on the answer. It has to be done continuously. It cannot be intermittent or have a break in there, and for a statutory period of time. So there's a statute of limitation in some states, and pay taxes in some states. Oh, I knew it. Let's see, what did you say? I knew it. Yeah, dang it. Oh, well, that happens. So let me type the answer and then I'll go into 232A. Okay, so C says using the property intermittently and without permission over a period of years. Well, every state is different. It has to be done continuously and it is openly. So openly possessing, meaning that anyone can see that it is being used, okay? And if the owner should be able to see it, unless the owner is not there locally, right? Then they don't get to see it. But it is not being hidden, right? They're not a secret person that's squatting on the property. It's visible to everyone. Therefore, and they have to prove that in court, okay? They have to show that they've been maintaining it, using it, and in some states paying taxes in order to be able to go to the court then and apply to take over the property. All right, number 33. And the owner may not have any choice, okay, when the adverse possessor, the person that is possessing it, squatting, a deadbeat person that's there, okay, if they can prove and justify it, and it's been openly and the owner should have known, then the judge will probably award it to them, following the laws, okay, the statutes of limitation. Okay, 33. So that was 32A. A buyer has signed a contract to purchase a property, but is uncertain of the condition of the title. Okay, so buyer signed a contract to purchase, to buy, but is uncertain of the condition of the title. They're not sure what the title is like. Which of the following parties is legally responsible for knowing the condition of the title? A, the county recorder. B, the seller's agent. C, the buyer. D, the mortgage lender. So which of the following parties is legally responsible for knowing the condition of the title? Who's buying the property? Okay, the answer here is C, the buyer. So it says, which of the following parties is legally responsible for knowing the condition? Well, it's the buyer. So the buyer would be requesting a title search to be performed while it is in escrow. Okay, and escrow means it's with the title company, and the title company will follow the instructions of the contract, and the contract says, hey, we want a search on the title. Make sure that it is free and clear. It is a freehold estate. It's a fee simple, has no encumbrances, no liens. If it does have some, they'll get paid before it closes. So everybody goes and signs. The money that comes in from the buyer or from the lender will be used to pay any debt that the owner may have on it, existing lien, an existing loan, or anything else. And then the leftover goes to the seller. But the title search, the buyer has to request it. If they don't request it and the agent doesn't advise them to get one, well, too bad. Buyer beware. Okay? They need to do their due diligence. 2 point. Oh, I already typed the answer. So let's see. The seller's agent, no, the agents are not legally responsible for knowing the condition. We're not attorneys. The title companies know that, and the attorneys, can explain, okay, the situation, the status of the title, any liens that are on it, not an agent. We are not, as realtors, responsible for that, and it's not the lender's responsibility. And yes, they are recorded at the county, okay, if there are any liens. So when the title company does the search, they'll reach out to the county recording office and get to see what kind of liens exist. Okay, so it is not the seller's agent. No, something like this. Remember, this is legal. Party is legally responsible. We are not attorneys. We are not legally responsible as realtors. Buyer agent nor seller agent. What we're responsible for is advising them to get one. Okay? And having an attorney review it if they don't understand it, or going to the title company who did the search and they will review it because they have their attorneys there. Okay? Y'all got it? All right, so we're going to number 34. Let's see if that worked. Bummer, bummer, bummer. All right, 34. Everybody okay with that? Let's see, we only had, okay, Jaylene and Jacqueline both answered C, only Tanya. So Tanya, I hope that you understood that we are not responsible as realtors, okay? So it is the buyer's, duty to do their due diligence. Okay, number 34, a break in the chain of title. 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 A break in the chain of results in, so a break in the chain of title to a property, right? Because the property's owners, okay, there's a history of the property title. So there's a chain, right? You have one link after another, okay, of ownership. Links. So results in what? A clouded title. B, a title plant. C, a lien and indeterminate ownership. Or D, a duplicate title. Good, Anna. I'm glad you understood it. So when there's a break in title, okay, you know, what happens? There's some kind of an encumbrance, right? So let's see, is anybody answering? Okay, so far we have A. Yes, that's correct. A clouded title. So there's a cloud in title whenever there's a break in the chain. So that's another type of cloud. The answer is A, a clouded title. All right, number 35. Wayne and Leota obtain an insurance policy that protects them from liabilities and losses resulting from title defects. The kind of policy they bought is a, so Wayne and Leota obtain an insurance policy that protects them from liabilities and losses resulting from title defects. The kind of policy they bought is a homeowner's insurance policy. B, a standard owner's title insurance policy. C, a lender's title insurance policy. Or D, a private mortgage insurance policy. Yes, Claylee, it's major clouded when there's a break in the chain. So what is number 35? Okay. What kind of insurance are they purchasing when it protects them from title defects? Type your answer in the chat. Question. Well, that is a good guess. Yes, it is a B, standard owner's title insurance policy. Standard owner. So it's the insurance policy that the buyer is requesting within the contract, okay, that the seller agrees to provide. And the title insurance policy is negotiable. You know, who pays for the title search? It can be the seller, it can be the buyer, it can be split. Okay, so the answer is B, standard owner's title policy. Now, when is there a lender's title insurance policy? Who asks for a lender's title insurance policy? Type the answer in the chat if you know that. Because there's two different title policies. When there's a lender involved, there's the standard owner's title policy, and then, no answers. The lender's title insurance policy. So the lender wants to also be protected. So they will ask for a lender's title insurance policy to be protected because they are providing a loan to the borrower. And the title search will search not only the seller's chain of title, okay, but it also searches on the buyer to see what kind of history the buyer has for any other records. No, Jaylene, it's not the buyer. It is the lender. I mean, yes, it goes along with the buyer, but the lender requires the lender's title insurance policy. Okay. And it's part of the cost that the buyer pays. So yes, you are, nope, not the broker. Title insurance policies have nothing to do with the broker. We as brokers or realtors recommend the buyer to request a title policy from the seller, from the owner. The title company also wants to be protected. So they have a lender's title insurance policy, you know, to be protected from the borrower or any, you know, issues on the title. Oh, wow. Yes. So the lender's title policy is by the lender. Yes, it's paid by the buyer, okay, because the buyer is getting the loan and they need the money. So lenders are going to protect themselves. All right, so 235 is B, very good. But the answer here was Wayne and Leota obtained insurance policy, and so they insured with a standard owner's title insurance policy. Oops. So if the title company cannot prove that the title is free and clear, a fee simple or a freehold estate, then they will not insure it and it won't close. The deal will fall out of escrow, just in case you were thinking. Okay. So number 26, Tanya, you answered C on which lender's title? Well, yes. So the lender is the one that does the lender's title, but the answer here is B. All right. Number 36. An owner transfers title to a property to a buyer in exchange for a motorcycle. This is an example of what? So an owner transfers title to a property to a buyer in exchange for a motorcycle. So you're exchanging a motorcycle for the transfer of the title. This is an example of what? A, voluntary alienation. B, involuntary liquidation. C, hypothecation, or 1031 exchange. So seller is transferring the title in exchange for a motorcycle, and that happens that way. Sometimes you don't need to have cash, okay, as the earnest money. It has to be a consideration. Yes, Kaylee, it is A. Kaylee and Jaylene. 236A, it's voluntary alienation, right? The owner is letting go of the property. They are alienating it. They're selling it. They're conveying it. They're transferring it. Well, it doesn't have to be a sale, okay? It can just be an exchange. So they're letting go of the property, and that's why they call it voluntary alienation. Bailey. Go over there. Good girl. Really? Why? Okay, so Jacqueline, you're talking about 36. Because whenever an owner is transferring a property, selling a property, okay, they're alienating it, and it's voluntarily. They're listing it on the MLS, or it's between a seller and a buyer, okay? And the word alienate means they're letting go their ownership of that property. Okay, so they're conveying the property, they're transferring the title to a property to a buyer because they want the motorcycle. So the motorcycle could be a very expensive one, worth $50,000, $60,000, $80,000. And they might have a small investment property that they want to do it in exchange. I'm trying to think of some of the really expensive. There's, BMW motorcycles. There's another one that my friends have, and I can't remember what they are. Very expensive. So it's for individuals that love motorcycles, and it could be a low property value. Okay. So you mentioned hypothecation. Let's see, right? Hypothecation. No. And hypothecation means to pledge something as a security for a loan without the actual delivery of the item pledged. Okay. So a car may be collateral. So here the motorcycle, it's not a collateral. It's an exchange. It's a trade. Hypothecation is they would be putting the motorcycle as collateral, okay, in order to be able to purchase that house. They would still owe money. Got it. Without lenders. Well, in this case, yes, it's without lenders. But whenever there's a lender involved, it's also voluntary alienation, okay? Because the owner is wanting to transfer title, they want to sell the property. It is still voluntary alienation when somebody is buying it with cash, the property is listed on the MLS, or they're selling it for sale by owner. They voluntarily let go of the property, alienate the property in exchange either for a motorcycle, in exchange for cash, or in exchange for a loan, which is actually giving them cash, okay, paying them cash for it. No, it's not. This particular question, yes, it's without loans and lenders. But voluntary alienation means to let go of the property, and it doesn't have to be just as an exchange. There can be loans and lenders, or it can be a cash deal. Because remember, the consideration in an offer in a loan doesn't have to be cash or a loan. It can be a promissory note, or it can be something else of value. So the something else of value here is the motorcycle. So this is just one way of doing voluntary alienation. I volunteer to give you my property in exchange for your beautiful motorcycle. Okay? That is just one example of voluntary alienation. So Jacqueline here was saying, so that's without loans and lenders. It is in this particular question. Okay? But it can be with a loan or cash also. You got that? Gosh, I'm trying to think of that darn real expensive motorcycle. I saw one just a few days ago. Now it's bothering me. Okay, I'm Googling it because now it's bothering me. I'm thinking of the word Akita, but it's not Akita. Okay, so anyway, there are some awesome, beautiful motorcycles that can be very expensive, you know, worth the value of a house, just like some cars, right? Some cars cost 100,000, 200,000, a Lamborghini, right? So they can exchange that house for that car or for that motorcycle. So who knows on here motorcycles? All of you on here, you're all women, but women, I used to own a motorcycle. So I rode motorcycles for years. Okay, come on, 37. I sold mine a few years ago. A Ducati. Yeah, Bugatti is a car. A Ducati motorcycles are very expensive. Thank you, Anna, for triggering my mind. All right, number 37. A person wishes to convey any and all interest in a property to another without assurance of the property's marketability. Okay, so a person wishes to convey, they're going to transfer the property, they're going to sell the property, and all interest in the property to another without assurance of the property's marketability. This party would most likely use which of the following types of deeds? A, sheriff's deed. B, a special warranty deed. C, a partition deed. Or D, a quitclaim deed. Okay, so the key words here, okay, they're going to convey it. They're selling it or they're giving it, okay, or exchanging without assurance of property's marketability. So in other words, there's no assurance that there is any liens attached to it. Okay, it's not having a title search. No, oh yes, it is. I thought I saw A. It is a quitclaim deed, right? Because there is no warranty. There is no assurance that it is marketable. So very good. So an ES1, so that's a different type of motorcycle. Not familiar with that one. But yeah, a Ducati. Actually, I think there is a car named a Bugatti. Very expensive. So 237D. All right, number 38. Jennifer owns a 1/2 interest in a condominium at a tenants in common with her business partner. Okay, 1/2 interest. So that's what, 50% ownership. Oh, and ES1 is the most expensive one. All right, Jacqueline. So Jennifer owns a 1/2 interest, 50% in a condominium as tenant in common with her business partner. If Jennifer has several heirs and dies without a will, the property will what? A, pass to the heirs by laws of descent and distribution. B, escheat to the state. C, pass to the surviving spouse based on homestead law. Or D, pass to surviving heirs according to the provisions of the will. However, dies without a will, right? Hey, Cindy, welcome to class. We're doing national first today. So type your answer in the chat. And while you do that, I need to go get a charger to make sure I don't run out of battery. So type your answer in the chat. Yeah, in the meantime, I love motorcycles and I still would love to buy one. All right, let's see. Everybody's answering A. And that is correct. Pass to the heirs by laws of descent and distribution. Okay, because it's tenant in common, right? It is 2 or more owners with equal possession and undivided interest, but they could have different percentage of ownership. And if they don't have a will, then it goes to their heirs by the laws of descent and distribution. Very good. All right. Number 39. Y'all did awesome on that one. A drifter secretly lives in an abandoned shack on a large ranch property after 20 years. Okay, after 20 years, a person makes a claim of ownership to the shack and the land immediately surrounded that he had cleared. This claim will be known, likely be what? A, upheld through adverse possession, upheld because of the length of possession. C, declined through the doctrine of prior appropriation. Or D, declined because possessive was secretive. So what does it say here? The drifter secretly lives in an abandoned shack. So remember, what adverse possession has to be what? Openly. So let's see, upheld through adverse possession. No, because it was secretly. Okay, so it can't be A. If it was a drifter openly lived in an abandoned shack, then that would be That would be okay. But there, the person is secret. So nobody knew for 20 years. Now that person makes a claim of ownership in the land that they had cleared. However, so upheld through adverse possession, declined. So this one would be declined because possession was secretive. Great, Jaylene. Yes, okay. A, upheld is if it was open, Okay, everybody knew about it. They're not being secretive. So in order to have adverse possession, even though they used it for 39 years, nobody knew. The owner didn't know. The public didn't know. So they have no way of proving that they have actually been there for 20 years, whether they've been maintaining it or not. So it would be declined by the courts because of that. So D is the answer there. All right, so number 40. To be marketable, title must be A, insured, B, free of undisclosed defects and encumbrances, C, abstracted by an attorney, or D, guaranteed by title of certificate. So type your answer in the chat. So what is that? In order for a property to be marketable, title must be what? Remember, no clouds. That's what the other question said. It wasn't marketable because it was cloudy. So what would this be? No, it is not D. Sorry. D says guaranteed by title certificate. No. In order for a property to be marketable, it has to be free of undisclosed defects and encumbrances. It cannot have any liens, any clouds, any defects, or any encumbrances. So marketable title is by definition one that is free and clear of undesirable and unknown encumbrances, claims, clouds, or other defects. Okay, so attorney's abstract and title certificate do not guarantee that a title is marketable. So those are abstracts. They did the search and they're providing the information, okay, but they can't guarantee by the title certificate, okay, that was issued, that it is free of undisclosed defects. When they do a search, okay, they'll find out. Okay, so do y'all get it? Let's see, most of you answered. Okay, well, some of you changed it from D to B. Yeah, so BBB, free of undisclosed defect. That makes it marketable. It's got to be a fee simple, a freehold estate, free of all liens, encumbrances. No types of liens, no types of loans, no types of trespassing, right? Encroachment, nothing like that. Okay, got it. Very good. All right, number 241. Okay, so quick question. Okay, we've already done 15 questions here. Do we do 5 more or do we go into state questions? And it would be Texas state. For anybody that here that is national in some other states and not Texas. So type it on the chatty chat whether I should do 5 more questions or move on to Texas state questions. And anyone who has just come in, we have been doing national real estate questions and answers that apply to all 50 states. And this is Lillie Handy coming to you from San Antonio, Texas with YouTube Agent Prep. If this is your first time to my channel, please tap that subscribe button, click that little bell so you're first to get notified, and like this video, thumbs up, okay? If you find it useful. There's several of you on here on YouTube, okay? So go and click that thumbs up, send me some love so that I keep doing these videos. 5 more. Okay, 5 more, got it. Very good. So majority wins because that's who replied. Okay, number 41. Which of the following types of leasehold estate lacks a specific term? A, estate for years. B, estate from period to period. C, estate at will. Or D, estate by the entireties. So which one lacks a specific term? Term, deadline, period, okay? So leasehold estate. Yes, estate at will. So what does the answer say? 3 of the 4 principal types of leasehold estate are estate for years, which has a specific lease term, the estate from period to period, okay, month to month, where the lease term of a specific period automatically renews, and the estate at will, which has no specified lease term. The 4th principal type, the estate at sufferance, okay, is a tenancy without consent that therefore has no specific term. So which of the following types of leasehold estate lacks a specific term? So the estate by entireties. So the estate at sufferance is a tenancy without consent, right? Because that is the deadbeat tenant, therefore also has no specific term. So the estate at will, which has no specified lease term, right? So it doesn't have at will. They can terminate at any time. That is the estate at will. So you all got it? Yes, very good. Awesome. Number 42. Okay, you all that are on YouTube, there's quite a few on you here. So tap that thumbs up, man. I don't like thumbs down. So if you can't say anything nice, don't say anything, really. Okay. All right. Number 42. A landlord generally has the right to enter the leased premises. When? A, at any time without notice. B, for specified reasonable purposes. C, provided the tenant gives prior permission. Or D, only 30 days prior to lease expiration. So a landlord generally has the right to enter the leased premises, right? If something's wrong, water heater broke, water leak, electricity's out. So how can they enter the premises of a property that they are leasing? Well, yes, it seems like C is the answer. However, what if the tenant is not there and there's a fire or there's a leak or the neighbor downstairs or by the side says, hey, water's flowing out of that apartment, okay? Do they have to wait till they get permission? No, in that case is they can enter the leased premises, B, for specified reasonable purposes. Okay, so, you know, there are emergencies, there are situations where they can go in without a tenant's permission. The tenant is out of the area, out of town, out of the apartment, and somebody else, you know, reports an incident that is crucial, then they've got to take care of it ASAP, then they can enter the premises. So y'all get that? Yes, okay. Number 43. When a tenant rents an apartment, he or she is usually responsible for what? A, compliance with the rules and regulations of the building. B, payment for an alteration of the lease space. C, recording the lease in the title records, really. D, occupying the premises throughout the lease term. So when the tenant rents an apartment, he or she is usually responsible for what? Good. I'm glad you all understand the prior question about how to enter an apartment or when the landlord can enter. Yes, very good. A, compliance with the rules and regulations of the building. Huh. Okay, come on. Something happened here. All right, so the answer is 243A. All right, number 244. Very good, y'all. You all, can you tell I'm from Texas? I didn't normally have a drawl accent. However, I say it funnily, having fun with it. All right, number 44. Under landlord-tenant laws, and every state has landlord-tenant laws, okay? And if you're ever going to be a landlord, make sure you know those laws. Landlords must treat tenants fairly and honestly. In a residential leasehold, this requirement would include what? A, ensuring the tenant against loss of personal property. B, providing required building support and services. C, guaranteeing that a fair rent is being charged. Or D, insuring the property for the value of the leasehold. Type your answer in the chatty chat. And anybody watching the replay, you can fast pace forward, since I give an opportunity to attendees, students to comment and type their answer. Hi, Marcela. Thanks for joining us. Yes, 44 is B, providing required building support and services. Right, a landlord has to provide all utilities and a habitable apartment or house, you know, an apartment in a building. So all the support and services. So very good. 244B. All right, number 45. Our last question for national. You asked and I delivered, right? You wanted 5 more? Gave you the choice. All right. 45. While a 1-year lease is in effect, the tenant dies of a sudden illness. In this situation, what happens? A, the lease automatically terminates. B, the tenant's estate has the option of canceling the contract. C, the landlord can record a lien against the leased fee interest. Or D, the tenant's estate is still obligated under the lease. So while a 1-year lease is in effect, the tenant dies of a sudden illness. So in this situation, what happens? Almost like, well, I'm not going to say any sufferance, right? Because the owner had a definite period, right? They had a 1-year lease, so didn't rent it to anyone. Well, you would think it is A. However, it says, the answer says the tenant's estate is still obligated under the lease. So if the tenant has an estate, okay, they have money or they have, other savings or other properties that they own. I mean, they're renting, okay. However, they could be an investor. They could own other property and decided to rent. So according to the answer is the tenant's estate is still obligated under the lease because it was a 1-year lease. A valid lease creates obligations that survive the death of the landlord or tenant, with certain exceptions. A tenant's estate remains liable for payment of rent if the tenant dies. The landlord's estate remains bound to provide occupancy despite the landlord's death. So, right, if somebody dies, if the landlord dies, then their estate or their heirs or whatever have to honor that lease. Okay. And also with the tenant, because the landlord made a whole lease. So now they're losing money. They've got to spend money to find another tenant. A lot of times, tenants don't have much money. In some cases, they will. So it just depends. All right, so the answer there is D. So it makes sense, Kaylee says. The tenant's estate is still obligated under the lease. And of course, it's under the discretion of the owner. Okay. So any questions, okay, on the national before I move on to Texas state questions? So while you think about that, let me start transitioning. Okay, so we don't have any questions. All right. Thank you, Jacqueline. I greatly appreciate your compliment. Said you're awesome with the national. Thank you. And I hope it's helping you in order to prepare and pass that exam. That's our goal here, right? Pass, 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 right? Affirm, I passed, and I passed, and become a realtor and have your real estate business. Okay, so we're going to stay with the same book. And we're going into Texas State. And we had very few questions on the contract. The next section is like matching, and it's hard to do it online. So I'm moving on. I'm moving on to special topic in Texas real estate. So let's see. Jacqueline says, I'm in Georgia, so I will see you all next time. All right. Thank you for joining us, Jacqueline. Yes. Awesome. It is you make it easy to understand. Oh, man. Thank you. I really greatly appreciate that. I get so many different comments, sometimes criticisms, okay, that it's too long. And I, have to comment that there are other websites for individuals who just want a quick question, answer. There's several other YouTube channels for that. However, I get into explaining the question and the answer because that's what you need to understand, right? So yes, for sure. Thank you, Jaylene. Okay, so this is what we're doing. Okay, and so anyone who's just coming in, this is the book that I'm using today. It's down on the comments. And so in the description down there, okay, and you can order the book. I love these books. This is one of the books that I really enjoy using because it has a summary of all the sections that you study for the exam or the books that you took. It summarizes them all. It has a math section. It doesn't have glossary, but that's okay. There's a lot of free glossary on the internet, okay, including on Quizlet. Okay, there's flashcards on Quizlet. And however, this book, to say it's all in one review and testing to pass Texas Pearson VUE real estate exam. And they have it for 25 states. Okay, this author, I spoke with Ryan Metling, the owner, the son of the company. And so they have published this book for 25 different states within the United States. They keep very busy updating, the Texas portion of it whenever any laws change. Okay, so let's go to Come on, where is the state? Okay, so I said we were starting with, okay, let me go to section 15. Actually, test 16. Okay. If you happen to buy the book, you can do the matching that they have the rest of test 15. All right, so this is on special topics in Texas real estate. Thank you, Kaylee, appreciate it. So special topics, a lot of students miss this, but there aren't that many questions. I think 2 or 5 questions, something like that. The agency, so the sections that you have a lot of questions are on standards of conduct, okay, in brokerage. You get a lot of questions on this, maybe up to 8 or 10. And also agency and brokerage relationships. You get a lot of questions on those 2 sections. And on special topics, there's not that many questions. And if anybody does Champion Real Estate, Champion splits their book, their review book, and they actually tell you how many questions on each exam for the broker and for the realtor, because it's basically the same exam. It's just the brokers have to answer more questions correctly. All right, number 1, 16.1. There we go. All right, here we go. Texas, change your hat. Oh, I chopped all my hair off. Almost. Okay, good. Oh, you did see shop. Okay. Yeah, when I took my classes, I did train agents, and sometimes I do CE for the continuing education. All right. So hold on. Let me get my stuff here together. Okay. So Texas special topics. Texas is a community property state. There are a total of 9 states that are community property. And how do I know that? I Googled it. Okay. Effectively, this means that A, once married, all property in both the states are owned equally between husband and wife. Once married, okay, so Texas community property state. So B, upon legal marriage, all property becomes owned as tenancy in common. C, spouses with some exceptions share property acquired during the marriage, but not what each owned beforehand. Or D, all property acquired following marriage becomes jointly owned without exception. There's usually some kind of an exception. Okay, what if they have an LLC? Okay. No, it is not B. Okay. Community property is similar to tenants by the entirety, right? Which is for husband and wife, not tenancy in common. So the answer here is 16.1C. Spouses with some exceptions share property acquired during the marriage, but not what each owned beforehand. Okay. Oh, I need to write something down here. So tenants in common, it's 2 or more individuals that not married. Okay. It can be partners, significant others, friends, business associates, anyone that buys it, 2 or more. That's tenancy in common. Community property in the state of Texas is for husband and wife. And they own property with some exceptions in case they have an LLC or something like that. They own it together during the marriage. They bought it during the marriage. So spouses with some exceptions share property acquired during the marriage, but not what each owned beforehand. So if they own something beforehand and let's say one of them was a rental and investment property. So the property owned beforehand is owned by that spouse only. However, any income that's coming in during the marriage from that rental, it is joint income. Okay, because that is income coming now. If they invest money to remodel it, to improve it, and that comes from them jointly, then they have to make an accounting of that, and both spouses will own a particular share while the improvements are made during the marriage. If nothing was made during the marriage, then the only thing that they own during the marriage is any rental income. If there's no rental income, then it stays with the other spouse that they bought beforehand. Okay, so 16.1C. So make sure you understand this has to do with the types of ownership that was on a different test. There are 4 types of ownerships, right? Severalty, tenants in common, which have no survivorship, joint tenants, TTIP, and tenancy by the entirety or community property in the state of Texas. That is for married individuals. So make sure you understand those, okay? So here are special topics, right? Because Texas is a community property state. All right, number 2. Oh, that didn't work. Okay, number 2. A husband in a community property state acquires a vacation property as a family gift, okay, on the first anniversary. A family gift. What is the ownership status of that property? A, each spouse owns half of the property. B, the wife owns half of the property but must forfeit her share if she divorces. C, the property is shared since the conveyance was not via an inheritance. D, the husband owns 100% of the gift. Remember, there are exceptions. That's one of the exceptions about everybody having the property own it equally during the marriage. Yes, the answer is D. The husband owns 100% of the gift. So whenever it is a gift, that is an exception. It doesn't belong to both. It is not community property. However, both have to sign whenever it is sold to make sure nobody's, both parties know about it. But a gift is 100% belonging to that individual. Now, if that gift starts earning money, okay, as rental, that belongs to both. We're number 3. Yep. Yeah. Okay. Number 3. Which of the following is not an accurate characteristic of homestead laws? A, homestead rights require a one-time filing with the county clerk. B, homestead interests are extinguished if the property is sold. C, the family must occupy the residence to qualify for the homestead. Or D, homestead property can only be voluntarily conveyed by both spouses. So homestead is automatic. However, in order to get the homestead exemptions, it does require a step, some action to be taken. So which of the following is not an accurate characteristic of homestead laws? So by saying that it's automatic, I basically gave you an answer. No one? So the answer here is A. Homestead rights require a one-time filing with the county clerk? No, they don't require. It is automatic if it is occupied by the family. So in order to be a homestead interest are extinguished if the property is sold. That is true. Okay. The homestead family must occupy the residence to qualify for the homestead. That is true. Homestead property can only be voluntarily conveyed by both properties. That is true because it is community property if they're married. Okay. So it can be conveyed by both. However, it is automatic homestead if it's their primary residence. However, in order to get their exemptions and have the tax amount reduced by a certain percentage, they do have to go to the county tax assessors and fill out a form in order to get that exemption, because they don't automatically get it, which is a bummer, right? It's automatically a homestead law because of how it was recorded on the warranty deed and the title. However, the county clerks doesn't automatically, at the tax assessor's office, actually, that's where they have to go and apply that form in order to claim the homestead tax reduction. All right, Jaylene, talk to you later. She's got to go bye-bye. I appreciate it. Number 4. Which of the following best describes a homestead tax exemption? A homestead tax exemption. A, an exemption from property taxation of portions of the homestead assessed value. B, a direct reduction in the homestead property taxes by a certain percent. C, a homestead property is exempt from taxation. Or D, a homestead property's equity is exempt from taxation. Remember what I mentioned. They have to go and do what? File a paper. However, the answer doesn't say that, but I did make another comment with the prior question about what happens. What's the benefit of a homestead tax exemption? Okay, y'all, there's quite a few of you here. Go ahead and type your answer. Take a risk. Right or wrong, this is the place to do it. The answer is A, an exemption from property taxation of portions of the homestead's assessed value. So the county tax assessor, right, has an assessed value, and a homestead allows in certain counties, okay, a 25% reduction, or in certain areas of the county assessed value. So it'll be a percentage that they apply to reducing the property taxes. So it says exemption from a property taxation of portions, so a certain percent of the homestead assessed value. And it'll show up on the property tax documentation, and it'll show up on the county records on the website. In San Antonio, it's Bexar County Appraisal District. So whatever county you are in, it'll show up on the appraisal district, on the property description. When you go search for somebody's public records, that's accessible to everybody. You could go to any county's county assessor's district. We call here, it's, what did I say? Bexar County Appraisal District. So we call it BCAD, County Appraisal District. So whatever county is County Appraisal District, you can go in there and you can look up any address, any person's name, and find out the value of their property. That is public information, right? That is constructive notice. Anytime it's recorded in the courthouse, in the county clerk, right, and at the tax assessor, the value, that is constructive notice. Once it's recorded, it's available to the public, and you can search it on the county records. Before, years ago, you had to go in person to look things up, and now they're accessible because of internet. accessible online. And once you become a realtor, you'll be utilizing that county appraisal district information, especially when you're going to list a property. So the answer was A, an exemption from property taxation of portions of the homestead's assessed value. But it has to be what? The family living there in order to be a homestead. And in order to claim that homestead, okay, assessed value reduction, they've got to go fill out a form at the county tax assessor. So it's not automatic. Having a homestead is automatic. Having the reduction, okay, the exemption is not automatic. All right, number 5. Which of the following is an accurate homestead tax exemption statement? An accurate, okay, which following is true? A 10,000 exemption for county purposes. B, a 15,000 exemption for school districts. C, the standard homestead amounts are granted to each family member resident. Or D, disabled persons can receive more than one residence homestead in a year. So they'll have a, this is not common answer to no, all right, unless you own property and you do have a homestead, okay? But it's not for county purposes, so disregard that one. So it's either B, C, or D. So is a homestead assigned exemption per family member or for the whole family? Okay, is it for disabled persons? They can receive more than one residence. When you know the laws of homestead, the rules of homestead, then it might be easier to answer this question. Actually, it is B. Okay, the answer here is B. And the reason being because it'll be a discount and exemption of school districts. Okay, so this is just, an example. So which of the following is an accurate homestead tax exemption statement? B, a 15,000 exemption for school districts. It's not for county purposes. It's for the benefit of the homeowner, the family that own that property, and it's their primary residence. We can only have one homestead in the United States. Okay. The C says a standard homestead amount are granted to each family member. No, it's not for each family member. There's only one tax assessment for the property. So it's for the whole family. D, disabled persons can receive more than one residence homestead in a year. No, only one. They can have 100% exemption from taxes if they are 100% disabled, and they will get benefit. If they're a disabled veteran, they'll get an exemption of a certain amount of the assessed value. So Kaylee said, that's right. Yes. So we're only allowed one homestead. Has nothing to do with being a disabled veteran or not. A disabled veteran will have another percentage allowed for them as a reduction. So you'll see on the tax assessor's property profile, okay, from the county district, appraisal district, it'll say on there might have a homestead HS, it might have a D for disabled, it might have 65 and over. So individuals of 65 and over, it freezes certain parts of the taxes, of the property taxes, okay? So there's different exemptions, and homestead is one of them. But we do have to go and report it and say, hey, okay, I want that exemption. So please give me that reduction of 15,000 for the school districts, okay? The one area that is not discounted much are the city taxes. Okay, so if you live in the county, you won't have any city taxes. That's why people like to live in the county. They have a lot of the other taxes, but not the city. Oops. Oh, come on. by using the books this way, unfortunately, this is how it works. Okay. And I do it in order to accommodate those that are watching it on the phone, on tablets, computers, to be able to see everything on one screen and large enough. So I usually, a lot of times, and I'm also looking at it on my phone. All right, number 16, 6. Following the tax sale in a foreclosure proceeding, a homeowner can regain full ownership of the property by paying all amounts owed plus fees and charges. In this scenario, which of the following is true? Okay, so 3 are wrong. 1 is a true statement. A, the homeowner may do this since he is exercising his equitable right of redemption. B, the homeowner may only exercise the statutory right of redemption prior to the tax sale. C, the homeowner may in fact exercise the statutory right of redemption provided the property is the principal residence. Or D, the homeowner may exercise the statutory right of redemption provided it is done within 3 years of the tax sale. Type your answer in the chatty chat. So when there is a tax sale, it's a foreclosure due to unpaid taxes. Okay. What is the redemption laws in the state of Texas? You may not know unless you learned it while studying, right? Come on, take a risk, take a chance, type an answer. Actually, I'm impressed with all of you doing it online, right? And just by reading and watching, you have to think fast, but that's how you're going to have to think fast on your feet at the exam day. So the answer here is C. The homeowner may in fact exercise the statutory right of redemption, which is 2 years in the state of Texas, provided the property is the principal residence. So the answer says the key here is before versus after the tax sale. So equitable rights of redemption apply to curing defaults prior to the tax sale. A statutory right of redemption applies to a period following the tax sale. So in statutory, the property must be a principal residence, and the redemption period in Texas is 2 years for their homestead and 180 days for non-homestead property. Okay, so non-homestead would mean it's a secondary residence. Okay, so they live in another state or they live an hour away. So it's considered a secondary residence. Okay, so it's only 180 days for a non-homestead. So if it is their homestead, then they have 2 years in order to pay back the taxes and all the fees and charges. So the first year of a tax sale that an investor buys the property, it'll cost the owner 25% of the taxes that were overdue, plus fees and charges. The second year, it'll be 50%, 25% for the first year, 25% for the second year, totals 50%. So if they owed $1,000, 50% of that is they're going to have to pay the $1,000 plus 50% interest, which will be $500 plus fees and charges. So it says a homeowner, so the tax sale happened. So it says the homeowner can regain ownership of the property by paying all amounts owed plus fees and charges. In this scenario, which of the following is true? So following the tax sale. So the tax sale already happened. It got foreclosed. It's not prior to. So A, let's see, did anybody answer it? No. Okay. The homeowner may do this exercising, no, not the equitable right. The homeowner may only exercise the redemption prior to tax sale. No. C, yep, 2 years of right of redemption, providing it's a principal resident. And in Texas, so D is not correct because it says 3 years. In Texas, it is 2 years. All right, number 7. Which of the following agreements are enforceable? A verbal 30-day month-to-month lease. B, an oral agreement to buy an oil interest in a property. C, a written lease signed by the landlord's son, an unauthorized representative. And D, an oral property conveyance between a judge and a juror. So which one of the following agreements are enforceable? Type your answer in the chat. No, it is not D. D has to do with, between a judge and a juror. And that is oral property conveyance. No, properties are not conveyed orally. It is in writing. Okay. So which of the following agreements are enforceable? In order to be enforceable, something has to be in writing, in a contract. Otherwise, the courts can't review it, whether it's a judge and a juror or not. Okay, so the answer here is a verbal 30-day month-to-month lease. Why? Because a lease less than a year does not have to be in writing. So both individuals have to present their case and show proof. Okay, especially one thing would be, making their monthly payment. Okay. B, an oral agreement to buy an oil interest in a property. No, that needs to be in writing. Okay. Those are like the mineral. So below the earth, right? The oil is down below the earth. And C, a written lease signed by the landlord's son, an unauthorized representative. That would not be enforceable. Okay. So the answer was 16.7A. Darn. Yes, I understand, Kaylee. But oral documents, you can't convey property, okay, with an oral document because it has to be legally recorded. If it is conveyed to somebody orally, well, it's still going to have the current owner's name on it. In order to change the name, convey it, the owner's got to sign the deed and deliver it, right? That's actual notice, signed, sealed, and delivered. And then it's recorded. Not required to be recorded, but it's best so that it becomes a constructive notice to everybody knows. The public knows. The world knows. Anybody who searches it on the county appraisal district will find it. Okay. All right, it fit all in one window, on one page. Number 8. Which of the following is a legitimate power granted to a landlord or a tenant? So there are landlord tenant laws in every state. So Texas has them too. So A tenant's right to vacate a week-to-week rental with at least 1 day notice. B, a tenant's right to apply the security deposit to the last month's lease in the absence of damage. C, landlord's right to evict a month-to-month lease tenant with 30 days advance notice. Or D, a landlord's right to waive liability for not maintaining habitability of the premises. So which one is a legitimate power? Okay, right, that a landlord or a tenant has. Which one makes common sense? If you can't think about it, which one makes common sense? Type your answer in the chat. Come on. Nope, no answers. All right, the answer is C. A landlord's right to evict a month-to-month lease tenant with 30 days advance notice. Okay, Kaylee, you said B. B says a tenant's right to apply the security deposit. No. They cannot apply a security deposit to the last month's lease. In the absence of damage, no. The landlord is allowed 30 days after the tenant leaves to determine whether there's any damages or not. So the landlord has 30 days after the lease, after the person alienates, right? After they leave, vacate the premises. So they've got to pay the last month's rent, and the security deposit is for any kind of damages done by them or their pets or their guests. Okay, so here the only correct legitimate power granted is a landlord's right to evict a month-to-month lease tenant with a 30 days advance notice. They can give them a notice, okay, and say, hey, here's our notice. We're giving you 30 days that we want you to vacate the property, alienate the property, let it go. We want it back. Okay, gotcha. Thanks. All right. Very good. Number 9. Which of the following is true regarding subletting a rental property? What is subletting? What is subletting? Anybody? So which of the following is true regarding subletting a rental property? A, tenant may freely assign unit if lease is for more than 5 years. B, tenant may assign to sublet but must return property to original condition prior to the subtenant's occupancy. C, tenants are free to assign their lease obligation but may not sublet without the landlord's permission. D, tenant must obtain landlord's prior consent to sublet the apartment. So subletting is when you're letting somebody else use your property. Use your rental because you don't want to utilize it anymore. You're moving out of town, you're moving out of the area, relocating, got a job transfer. Therefore, you get somebody else to do it. But can you do it without permission? That's right. The answer is D. Tenant must obtain landlord's prior consent to sublet the apartment. And it'll usually be in the lease agreement if they have a lease for at least a year or more. If it's a verbal lease, right, for a year or less, then they've got to have written permission from the landlord. Or oral permission from the landlord. Better to get it in writing, okay? Always. To protect, right? What is it called? CYA? Cover your, you know what? So tenant must obtain landlord's prior consent in order to sublet the apartment to somebody else. But if they sublet it to somebody else, they are still, the original tenant is responsible for making sure that the rent is paid. And if their friend or whoever they sublet it to doesn't pay, they're responsible. They have to pay for it, even though the other tenant is living there. All right, number 10. All right, number 10. Which of the following is not a landlord justification for keeping a tenant security deposit? So when can the landlord keep a security deposit? Okay, what is that for usually? A, to eliminate normal wear and tear to the apartment, including painting and carpet cleaning. B, to offset rent owed by the vacating tenant. C, to repair damages to the plumbing system. Or D, to cover excessive damage caused by a dog, even though dogs are permitted. So which one is not a landlord justification for keeping a tenant security deposit? Make sure you read that correctly, because I was almost going to, choose a different answer. So 3 of them are okay for using the security deposit, but 1 is not. Because remember, a rental is an investment. Not quite, Tanya. So take another attempt at it. The answer is A. A landlord cannot keep money, from a security deposit for normal wear and tear of an apartment building or a house, including painting and carpet. That's part of owning a property and investment. That's improving their own investment, okay? It is for offsetting rent owed by the vacating tenant. It is to repair damage to the plumbing system. Okay, if the tenant created some issue, clogged the plumbing, threw stuff down the toilet that they shouldn't have, or into the garbage disposal or the bathtub and sink, then that could cause damage to the plumbing system. Then the landlord can justify keeping some of that security deposit. To cover excessive damage caused by a dog? Yes, okay, because even though dogs were permitted, a lot of times there are dog deposits and monthly dog rent. So the answer is A, 1610A. Okay. That one is not justifiable. Wear and tear of our investment property, that's our responsibility. And we know that that's going to happen. And that's why we charge a certain amount of rent to include wear and tear, right? Number 11. So typically when we own an investment, more than likely we're going to, a good landlord, that wants to maintain the value of their property will repaint it every time somebody vacates, repaint the whole thing to make it fresh for a new tenant, replace carpets, replace flooring. That also maintains the property value and allows for being able to charge more, right? So 1611, in maintaining proper relations with tenants, landlords and tenants are obligated to meet certain apartment security standards. Which of the following accurately identifies one such standard? A, tenants may alter security devices, but at their own expense. B, landlord must install window locks in occupied buildings. Tenants must install security bars for glass doors. C, all security devices must be repaired within a 30-day time frame following tenant's written notice of the disrepair. Or D, the landlord must rekey the locks within 7 days following a tenant's vacating. So which one? In maintaining proper relations with tenants, landlords and tenants are obligated to meet certain apartment security standards. Which of the following accurately identifies one such standard? So when a tenant moves out, what is probably a good idea for the landlord to do? Or for the tenant? Okay, depends. Type your answer in the chat. Come on, come on. Those of you that are still here are diehards, right? Well, because you need to study for national and state. The answer is actually D. The landlord must rekey the locks within 7 days following a tenant's vacating. Why? Because, if they have the same keys, a prior tenant could come back, right? And be a squatter. And so that is a security, what is it? That is part of the security standards. So Landlords and tenants are obligated to meet certain apartment security standards. A landlord does not put security bars for the glass doors. That is a landlord's responsibility, especially if you're on an upper floor, right? Or some types of locks on the windows. That is not a tenant. All security devices must be repaired within 30 time day frame following a tenant's written notice of the disrepair. So which one is required? The landlord must rekey the locks within 7 days following a tenant's vacating. Now, if they rent it quicker than that, then, replace the locks immediately. Right? 16D. So tenants may not alter or remove security devices without landlord's consent. However, landlord's responsible for windows, latches, all exterior door locks, and glass door security bars. Repairs must be made generally within a 1-week time frame. So C is not correct because it says within 30-day time frame. Okay, and B, landlords must install window locks. Tenants must. No, it's not a must. They can, but it's not a must. Okay. So be very careful of little words like must. That means it's absolute. They have to do it. And that's not necessarily true. Or I should say that is not true. A landlord can choose to do it, but it's not required of a landlord. Okay, number 12. Texas Property Code Chapter 92 is very specific about fire safety regulations. According to code, A, there must be a smoke alarm on at least the ground level of a 2-story duplex. B, fire alarms must be inspected annually by the landlord. C, tenants are responsible for inspecting and repairing fire extinguishers. Or D, there must be a smoke alarm in every bedroom of a dwelling. And this is not just on rentals. So actually, it doesn't talk about rentals. It just says Texas Property Code. Type your answer in the chat. Yes, Tanya. The answer is D. There must be smoke alarm in every bedroom of a dwelling unit. Okay, that is to prevent, children, everybody to exit and make sure they hear that there's a fire or smoke, okay, in that property. And it has to be now on every bedroom, and in the hallways, and the kitchen. And downstairs and upstairs. Okay, number 13. Utility service to tenants is regulated by Property Code 92. One of these regulations is that what? A, tenants are responsible for all utility charges if the apartment lease exceeds 1 year. B, tenants may not pay a landlord's utility bill to avoid any service interruption. C, the landlord may not cause utility service to be interrupted to the tenant as means to collect unpaid rent. Or D, if a tenant is forced to pay a landlord's water bill for the apartment, the tenant nevertheless must continue to pay rent in full. So utility service to tenants is regulated. One of these regulations is that. So which one is true? Type your answer in the chat. Oops. Oh, come on. Type your answer. Take a risk. I'm going to move right along. The answer is C. Tenants are, the landlord may not cause utility service to be interrupted to the tenant as a means to collect unpaid rent. There are some slumlords out there that will do that. Okay. However, it is not legal. It is not legal in the state of Texas to do that. Number 14. Leases may be terminated in legitimate ways or by other means which may be unlawful. Which of the following is a perfectly legitimate cause for lease termination that does not carry a legal or financial liability? A, abandonment. B, conveying of the property by landlord to another owner. C, death of the tenant. D, expiration of the lease term. So which of the following is perfectly legitimate cause for lease termination that does not carry a legal or financial liability? All right, y'all, type that answer in the chat. Take a risk. It's good to participate. I'll help you if you don't understand it. Very good, Tanya. Yes, D, expiration of the lease. Awesome. The others not, right? If you abandon, you still have financial liability. Landlord cannot convey to another. They must honor the lease. And death of the tenant, we already read that their estate has to pay for the lease, the remainder of the lease, unless the landlord pardons it, right? Number 15, when tenants default, the landlord may evict by following the correct procedures. Which of the following actions would be considered proper eviction procedure? Which is proper eviction procedure following the landlord-tenant laws of the state of Texas? A, the landlord with or without proper notice can lock the tenant out of the premises. B, the tenant files for a suit for possession. C, prior to filing a suit for possession, the landlord gives the tenants 14 days written notice following default where tenant does not vacate. Or D, armed with a writ of possession, the landlord gives notice of the demand to vacate, including removal of personal property. So there are proper steps that must be taken through a small court, a justice of the peace in a local small court. Things get done much quicker there than in the major courthouse. So can the landlord lock them out? No. The tenant files suit for possession? No. Okay, they can possess it while they're using it, but the tenant defaults. So, why would they be filing suit for possession? C, prior to filing suit for possession, landlord gives 14 days written notice following default where tenant does not vacate. Or D. So yes, they're going to follow an eviction notice, right? But the actual accurate answer is armed with a writ of possession. Okay, so they've gone to the court to get possession of the property. The landlord gives notice of demand to vacate, including removal of personal property. So, landlords will provide an eviction notice, okay, 72 or 30 days, or depending on what the default is, the type of eviction, and then file it in the local jurisprudence courthouse, a smaller court. And then they'll have to actually take over and possess it, because an officer will go and present the writ of possession or to vacate. And they'll say, hey, you have 24 hours, out of here. And they're like, oh, but I need more time. Hey, they already gave you enough time. You're out. Okay. That's why they took this step, major step, to get you out. You had enough time. I've been there, okay, with some of my tenants, okay, that are still begging for extra time, and the cop says, nope. And sometimes they'll only say you only have a few hours to get out. Like they'll go in the morning and they say, hey, you got to be out by 2 o'clock. Out. If not, they'll just lock the door. And the tenant is out. No excuses. No him and ha. No feel sorry for me. Sorry, you knew what you were doing. All right, number 16. So nobody answered that one. Oh yeah, Tanya did. No, not 15. Oh, I wrote down I said 16, 15, and it's actually 16. No, actually, oh yeah, we're on number 16 now. Okay, that was 15. Okay, I'll get it sooner or later. Okay. That didn't work. Okay, number 16. Kaylee says, thank you so much for your time and knowledge. See you next time. Wow, Lillie. Yep, that's it. Wow, Lillie Hendy, like my shirt says. Wow, Lillie Hendy, right? And this is from my my trainer, TTS. So Tenant Training System. Thank you so much, Kaylee. All right, number 16. Constructive eviction is best described as which of the following? Constructive eviction, okay, is best described as which of the following? A tenant self-eviction where the tenant with notice abandons the apartment due to the landlord's failure to maintain habitability. B, a tenant abandons the apartment and the landlord makes the vacancy official by filing a constructive eviction notice. C, a tenant in a dispute with the landlord withholds rent until his or her deposit is returned. Or D, a landlord forcibly evicts a defaulting tenant in lieu of writ of possession. So which one is constructive notice is best described as which of the following? To remember, there's actual notice and there's constructive notice. So there's a difference, right? So which one is constructive? Okay, the answer here is A tenant self-eviction where the tenant with notice abandons the apartment due to landlord's failure to maintain habitability. So the constructive eviction is the tenant informed the landlord in writing. Okay. However, if the landlord doesn't get the notice, okay, it's still a constructive eviction. Remember, constructive eviction can be recorded. And so that's what the tenant could do. Okay. Go to the local little courthouse and file a self-eviction because the landlord has to maintain habitability of an apartment or of a house. So tenants can also take action against the landlord if they're paying rent and the landlord is not providing a habitable house or home or apartment. So they self-evicted. Okay, so they filed a self-eviction. That is constructive notice. All right, number 17. Non-judicial foreclosures, which we have in Texas, like best legal proceedings, require that proper notice procedures be followed. In this proceeding, the notice of sale must precede the sale by A, 7 days, B, 14 days, C, 20 days, or D, 21 days. So in the state of Texas, when you're in default, when can the non-judicial foreclosure proceedings start? Okay, with proper notices. How many days in the state of Texas before, in order for the trustee of a deed of trust, right, because it's non-judicial, can start sending letters? of default or filing a foreclosure. So the notice of sale must precede the sale date by D, 21 days. From the state of Texas, when they're in default, so the notice of sale must precede the sale date by 21 days. So they're in default 21 days, and then the trustee can start providing that notice. It doesn't mean they'll foreclose that day. They have to send notice. The notice of sale must precede the sale date by 21 days. So they deliver the notice, and then the sale date can happen according to the notice that is provided. So it's minimum 21 days. All right, number 18. In non-judicial foreclosures, the foreclosure price may be less than the loan amount, or it may be less than the market value. With that as a given, which of the following is true? A, if the foreclosure price is less than market value, the lender may pocket the difference. B, if the foreclosure price is less than market value, the debtor is entitled to an offset equal to that margin. C, if the foreclosure price is less than the loan balance, the creditors must absorb the difference on their books. Or D, if the foreclosure price is less than the loan balance, the creditors have 3 years to recover the difference from the debtor. Type your answer in the chat. Tough questions, huh? So the answer here, which in Texas, we have a non-judicial foreclosure when there is a deed of trust, and when the price is less than the loan balance or less than the market value. B, if the foreclosure price is less than market value, the debtor is entitled to an offset equal to that margin. So there could be a deficiency owed, okay? So it doesn't mean that they are relieved of any debt, okay? However, there is an offset equal to that margin of how much it is lower than the market value or lower. So in this case, it could have been lower than the loan amount or less than the market value, okay? So the foreclosure price may be less than the loan amount or less than the market value. So if it's less than the market value, however, it pays off the loan, then they can have an offset equal to that percentage, right? And they could be provided the difference after, attorney fees, other court fees, any fees and charges are made. If there's any money left over, the borrower or the debtor, okay, could get that. If there's still a balance owed, then there probably will be a deficiency, meaning that the lender is going to require them to pay any balance due. And they can set up with the lender a payment plan, or the lender is going to put a lien on other properties they own. It's kind of hard to put a lien on a personal property unless the borrower goes and does a bankruptcy, then that would stop the foreclosure. Okay, and the bankruptcy court would then determine, and they could actually get the money from other assets, depending on the type of bankruptcy. Okay, number 19. So in a foreclosure, the lender doesn't pocket the difference. If there's some money left over, it goes to the borrower. The creditor must absorb the difference on their books. No, there'll be a lien deficiency. The creditors have 3 years to recover the difference. No, they can, until the borrower pays it off, there is no, deadline or statute of limitation. Okay, number 19. Probably not going to work. It was close. Okay, number 19. In a judicial, okay, this means they have to go to the court to get a foreclosure. The court issues a judgment to sell the collateral property. Okay, the collateral is the property that the loan was made on. Following the sale, the debtor has a window of time to determine if there is an excess of market value over and above the sale price. If so, the debtor may obtain an offset for the difference. This window of time is A, 90 days, B, 180 days, C, 1 year, D, 2 years. So how much time does the debtor have to get that offset for the difference? These are challenging questions. That's why a lot of individuals miss the special, what is it? What's the special topics? Okay, special topics in Texas. Okay. The answer here is 1 year. So if so, the debtor may obtain an offset for the difference. This window is a 1 year term that they can get that difference from the lender. Because who is doing the foreclosure? The lender, right? So if the lender got more money than what was owed on the loan, then the borrower is due that excess money after all expenses are paid. Whatever money is left over, then they get that. So the statute of limitation for that borrower, for that debtor, is 1 year after a judicial. Judicial foreclosure is when there is a mortgage, not a deed of trust, okay? And the court has to issue a judgment to sell that property, which is the collateral for the loan. And the window of time that debtor has, okay, in order to get, if there's an excess of market value over and above the sale price, is 1 year. All right, number 20. In a short sale, the sale price is less than the mortgage amount. Which of the following is a critical issue for the seller in completing a short sale? So when there's a short sale, the owner still owns the property, okay? And the lender will be negotiating if the amount is less than the loan amount, than the mortgage. So A, obtaining an appraisal value that exceeds the mortgage amount owed. B, the seller is getting the buyer to agree to make up for any deficiency. C, getting the lender to provide a full release of the lien at closing. Or D, reporting the correct amount of debt forgiveness to the IRS, if there is a forgiveness. Okay, so in a short sale, that means the lender is getting less money than the mortgage that is owed. This happened a lot starting in like 2007. You know, all the market dropped tremendously, and there were a lot of foreclosures and a short sale. Foreclosure means the owner already owns it, okay? They foreclose on the borrower and they get the property. Now they sell it as real estate owned. A short sale, the owner still lives in the property or owns the property, and they're selling it to prevent a foreclosure, which ruins the credit a lot more. So here, yes, Tanya, the answer is C, getting the lender to provide a full release of the lien at closing. That is correct. I did a lot of short sales in Oregon, Southern Oregon, because that's where I was when the market crashed. And I moved to Texas and I continued doing short sales in Southern Oregon because I had my Oregon license. I was not doing short sales in Texas because I didn't have a Texas license, but I was continuing to help clients in Oregon. because basically that is done on the internet, negotiating with the lender, listed the property, and realtors get to go see it, right? I didn't need to be present, and if I needed any help, I'd call an associate realtor. Okay, so that was in a short sale, getting the lender to provide a full release of the lien at closing, even if they got less than the mortgage amount. So if the lender is going to still, is not going to forgive the debt, okay, they'll have a deficiency, okay, but the borrower can get into a payment plan and the lender will release the lien at closing. So if they release the lien easily, that means they might be forgiving the debt and report it to IRS. Then why report it to IRS? Because that was a debt that the borrower had and the lender, forgave it, but they still have to pay taxes on that money that was borrowed. Interesting, huh? Yes. All right. So that is it for tonight. So if you have any questions, right now is the time to ask. So any questions? So the book that we're using was this, Texas Real Estate License Exam Prep. And it is down in the comments in the description that you can order it. It's like books that I use, okay, for exams. And you can purchase them on Amazon using my link. And yes, Amazon will provide me with a minor affiliation fee. Okay, if no further questions, okay, I do these classes, okay, these prep classes, Monday and Wednesday evenings at 6 p.m. and on Saturdays at 10 a.m. And they can run from 1 hour to 2 hours, sometimes less, depending. But lately we've been doing national and Texas, because the national applies to all 50 states, right? And then they have to then study their state portion, somewhere else. And I plan to do some of that on here also for other states. And then for those of you in Texas, of course, you get to see this. So anybody watching the replay, this was for national and Texas state questions, preparing you for the exam. These are sample exams taken from these books, where these authors get them from different avenues. Sometimes they get, older questions from Pearson VUE or PSI or whatever the examiner, the tester is in the particular state. Okay, if no further questions, this is Wild Lily Handy with YouTube Agent Prep, coming to you from San Antonio, Texas. All right, and at any time that you have any questions, hey, send me a text, message on Messenger, or type it here on YouTube or on Facebook. I would prefer if you do it here on YouTube, right? And provide some more activity for my channel, and that I finally hit 1,000. So, yoo-hoo! You're very welcome, Tanya. And so if this is your first time to YouTube, okay, YouTube Agent Prep, remember to tap that subscribe button, click that little bell so you're the first to get notified, and thumbs up if you found this video useful. Okay, no thumbs down, all right? If you can't say anything nice, don't say anything. All right, y'all. Until next time, catch y'all later. Love ya. Study, study, study. And the vocabulary. I see that many people don't study vocabulary, okay? So study that vocabulary. Catch you later. Pass that exam. I passed, I passed, I passed. The goal is to become a realtor, right? Yes.